Welcome to Felony Miami, the show where we have real conversations with real people about the criminal justice system in these United States.
Well, it's early in the morning, then when I ride, Lordy Mama. Well, it's early in the morning, then when I ride. Well, it's early in the morning, baby, when I ride, baby, help me down, help me my right side.
Is this a game of Let's Make a Deal, The Price is Right, The Wheel of Fortune, or Double Jeopardy? If you end up on the wrong side of the law, you're probably going to get offered one of these deals. It's called a plea bargain. The plea bargain is a negotiation between the prosecution and the defense in order to reduce the amount of cases that will go to trial in an already overburdened criminal justice system. This negotiation will ultimately determine the fate of the accused. Even though it's not up to the defendant to prove his innocence, it seems that in a plea bargain situation, the best deal might be to take what's behind curtain number 3. Some are good deals, some are bad deals, but they're all the real deal, because in the end, it's someone's life that's being played with. Where there's injustice for one, there is injustice for all. Welcome to Felony Miami. Let's air it out. Hi, and welcome back to Felony Miami. I'm your host, Joe Stone. In the studio today, we have 3 guests. To my right, we have Jake Cattell, award-winning author and filmmaker. Thank you for being here, Jake. And you're also one of the producers of the Felony Miami show. We appreciate you coming on the show today.
Oh, yeah. Thank you. Should be cool.
Oh, yeah, no doubt. Straight across from me is Bradley Horenstein, Miami native and a former public defender. Bradley Horenstein handles cases in criminal defense and general practice. Bradley graduated from Palmetto High School. Jeff Bezos. Me too. Thank you very much. Attended Hofstra University for law school and has been featured in the Herald and met his wife through working in the public defender's office when she saw you in the courtroom doing your magic.
That's right.
Nice. Welcome to the program. Thank you for being here.
Very happy to be here.
And to my left, Sara Shulevitz, former public defender, former prosecutor, currently in private practice. She calls herself a zealous advocate for the accused. Sara is also a broadcast media personality, as featured on this Sara Shulevitz show, a legal fashionista. She looks fabulous. And works with the ABC Live Well Network and the NBC Nonstop Network. And you've been in the New York Post and the Herald and published all over the place. Thank you so much for taking your time and being here today.
Thank you so much for having me here.
Of course. So I want to just get right into this because to me, the program that we're talking about today is this whole plea bargain concept. And I know that the whole concept of our program, the criminal justice system and the injustice that's happening out there to our fellow Americans is on the tops of a lot of people's minds. It's it's a bipartisan issue. It's not left or right because this affects all of us and all of our communities. And this whole concept of the plea bargain, I think it's a uniquely American concept. Am I right about that?
I've practiced, in Miami, and I have an office also in New York with a law partner. And from what I understand from other colleagues that I've spoken to international, they don't have a similar concept. But as a former state attorney and former public defender and having done both sides, our system is based on plea bargaining. Without the idea of the plea bargain, the system would explode because they can't try every case. And,
Is that because we arrest too many people?
Of course.
Yeah?
Yeah. With regard to your first question, I don't know what the practice is for plea bargaining outside the country. Mm-hmm. But I know there are not jury trials in most countries. And so if there are not jury trials in most countries, then what I imagine is the prosecutors, and you can tell me if I'm wrong, don't have as much of an incentive to offer a plea agreement, because if you don't have a jury of your peers, who a lot of the times is the conscience of the community and will get rid of a case if it's not proven beyond a reasonable doubt. In another country, if you have a judge or you have some sort of panel that are going to make a decision, it's very likely that that is going to be a high rate of conviction. So in those circumstances, the prosecutor doesn't really have an incentive to close it beforehand because they know that they're going to get the conviction. In the United States, jury trials, a lot of the time end up in a acquittal. In federal court, it's a little different, but in Miami, at least in state court,
When you say acquittal, what does that mean?
that means not guilty to any of the charges.
To any of the charges.
Right. So there could be partial verdicts. You could find someone could be found guilty of lesser charges. So, like for instance, if you're being tried for burglary, the jury can come back guilty on trespass, which is a misdemeanor. And if a prosecutor doesn't have a strong case on a burglary, they think the jury may come back trespass or may come back not guilty, then they're going to resolve the case prior to trial, which is what most often happens. Also because you don't want the court system logjammed with trials. But outside the country, I'm not sure how it works.
But the thing is that there are situations where people don't have resources and they don't have good attorneys or investigators, and they're not able to afford that. And they could get railroaded and they get convicted and then they get sentenced to jail terms, and that ruins their whole life because it's a domino effect. Then they can't get employment. So a trial is very risky to people and a lot of people that don't have the resources to have an attorney, private attorney, or public defenders are also excellent, but there's so much risk involved and so much cost, personal, that a lot of people can't take the risk, and then they end up accepting plea deals.
And I mean, I think the concept that the public defenders are overloaded and overworked is pretty widely accepted, right?
Yeah.
I mean, because
Yes.
these are clearly good people. You've both worked on that side of the law to be a public defender. And, listen, this concept that everyone deserves a fair trial goes way, 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 way back in our history.
Yes.
And each case has so many facets to it. And as a public defender, and you can speak to that, we would have like 80, 100, 150 cases at a time, and you can't send an investigator on every case, and you can't take the time, because really to defend someone adequately, you have to know about their life, their childhood, what happened, all the dynamics. And many cases, when I was a prosecutor, I would look at the police report and the charging document, and I was a prosecutor at 23, and from an ultra-Orthodox Jewish background, so I just assumed that everything that the police said were true.
True.
Yeah, and everything that was charged was true. And then you come to see that there's a lot of mitigation. People have psychological issues. People come from destitute backgrounds. And without compassion in the law, you're just harming society, and people need treatments and rehabilitation. And an attorney, we have to kind of be like a therapist,
Sure.
counselor. Yeah.
I think what she said is very important because you're talking about having believed every officer,
Yes.
right, when you started. Officers can lie.
Yeah, it happens a lot.
They can be wrong about the law.
Yeah,
They can racially profile.
it happens all the
You cannot find these issues out, unless you investigate each case. As a public defender, let's say you start with the third-degree felonies, you could have in fact, routinely you will have well over 100 clients. That's 100 names to remember, plus every cop who arrested them. That's 200 names, plus every other witness listed, plus all the circumstances behind. It's very difficult to command the information with regard to each case.
And as a public defender, do you have a team that you're working
No.
with? No. It's
No,
just
you are alone on an
time.
island.
They give you
Really?
sometimes, if you really need, you can have an investigator, but the resources are so limited, and they won't go beyond the scope.
But conversely, does the prosecution have a team? Or are they also an
I think
island?
it's the same thing. I mean,
Well,
what they have is,
yeah.
and you can speak
Yeah.
more to it, but they have supervisors who
Right.
have to approve any decision they make,
Right.
whereas we really are autonomous.
Oh, you are?
We have investigators, we have mitigation specialists, we have money to hire experts. We can certainly get help on our cases, but you
limited.
still have to be the person who understands everything for each case, has to have the time to answer phone calls from everybody. And when I left the office, I was there for 6 years. When I left, I was only handling first-degree felonies. Basically, everyone's facing life. And I had over 50 cases. I had over 40 clients. All of them facing basically life in prison, but at
Yeah.
a minimum of 15 years.
That's a tremendous responsibility.
Right, but
Yeah.
but what I will say about the Miami Public Defender's Office is there is no better
Yes.
law firm in the city
Really?
than the Miami-Dade Public Defender's Office,
Yeah,
or maybe the Federal Public Defender's Office in Miami as well.
Yeah,
They're
public
both excellent.
defenders are often, undervalued. when I asked my clients, "Oh, who was your prior lawyer?" They're like, "It wasn't a real lawyer. It was,
Right.
they didn't realize." But the public defenders are very diligent.
That's
But,
good to know.
Yeah.
Oh, yeah.
But
That is a misconception in this community that needs to change. Public
Yeah.
defenders are excellent here.
Yeah.
But it's good to have a
If
project.
you're not spending
good to know.
if you're not spending tens of thousands of dollars on your legal defense and you qualify for a public defender, keep
Yeah.
the public defender.
Now,
Federal
what
or
qualifies somebody for a public defender? It's obviously
have to be
based on your
indigent.
income
state.
or
Based on your income, based on how many dependents
Yeah.
you have,
Okay.
based on how much money you owe every month. I don't
So-
know what the threshold is, but basically, if you
Yeah.
make $20-something thousand a year, you're qualifying for a
But
public
Okay.
like you were asking before about like so the as a public defender, like you were saying, you're basically on your own. But as a state attorney, you have the resources behind you, backed of police officers, investigators, and on federal cases, the U.S. attorneys. They have a very high conviction rate because they have federal agents, DEA, FBI that, if someone's going to go to trial, they're going to use all guns against them.
Now,
Yeah.
we're going to get to the whole concept of the plea and how you guys arrived at that in 1 second. But I'm curious because one of the things that I've heard is that one of the prosecution's tools and mechanisms for putting out the concept of taking a plea is there is a penalty or could be a penalty if you go to trial and lose. Can you explain that?
Yeah.
Yeah, it's called trial tax, and it's absolutely inappropriate.
But it happens all the
It's
time.
called trial.
Trial tax.
Well,
Oh, yeah. And
Are
it
there
happens
any other
all the-
euphemisms for that?
No, we call it trial tax, and what it is and you can explain it also, but a judge is going to punish you a lot of the time for going to trial and
costs.
wasting the money and wasting the court's
The
time.
judge?
The judge. Now,
Bro.
but the judge will explain it, and it'll be protected in the Court of Appeals, should there be any challenge, by simply saying, throughout the process of the trial, I learned more information that I didn't know at the time that this trial started, and now I'm giving you a higher sentence than was offered initially because of that. That's how they protect themselves, but that's BS.
But as
Right.
a former
Yes.
prosecutor, I understand that also, on the flip side, because it costs the government money to bring in the witnesses, to deal with everything, and it's not fair to the defendant, but, otherwise people would bluff and the prosecution wouldn't be able to handle it. So they kind of,
What do you mean by
they give you
that?
deadlines to take.
What do you
pleas.
mean by that? That
do you
that they would bluff?
Oh.
Who would bluff?
So the not bluff, but the prosecutor's interest is to have a conviction. The Miami State Attorney's Office happens to be amazing and extremely ethical.
Okay.
They taught us not
you-
to file charges unless we had a good faith basis.
Okay.
And it happens to be that the boss of the State Attorney's Office is exceptional.
So
Yeah.
the concept of the bluff is part of the whole.
They taught us not to do that.
I
but
think the state
when-
attorney's office bluffs every single sounding, personally.
Everyone.
Really?
They sound ready on every single trial, no matter what. Whereas at the public defender's office, we don't sound ready for a trial unless we are ready
And
to
saying
go.
"sound ready" is something that you say in front of the judge, like we're ready to take
So-
this to trial.
So most
Trial.
courtrooms 10 days before a trial will have what's called a sounding calendar, where both parties go up and announce whether or not they are ready for trial, and then 10 days later the trial will commence. These are usually on a Thursday, not the following Monday, but the Monday after that. 10 days later the trial will commence. The prosecutors routinely sound ready on every trial.
And they're not.
No way.
No way.
No way.
No way.
Wow.
No way. But that's a bluff if you want to talk about bluffing.
Yeah. I mean,
Now-
it seems to me that there is a bit of a chess game or a
Yes, it
poker
is.
game.
here-
Something's
Oh, yeah.
going on.
Here's the problem, though. For us to bluff, and by us I mean public defenders, I left the office about almost 4 months ago, so I still feel like I'm part of it.
Oh,
I've been
sure.
in private practice over a decade, 11 years. So I
Yeah.
left the government already. I've been practicing.
So
since
you've
the-
been out
Yeah.
for a minute, but Brad is fresh out of
Fresh
the
out.
box.
And I
Okay.
did 6 years there, and by the end I was trying murders.
So you did
Yeah.
6 years.
Yeah, exactly.
Hey, but here's what I would like to know. Have either of you ever seen real corruption in the system?
Yes.
Tell me about it.
Yeah.
I'm thinking because I don't think that I've been privy to seeing it, but I'd love to hear.
I
what you say.
have. When
What
I
have
was
you
a
seen?
prosecutor, I would have cops come in sometimes that would say, "What do you need me to tell you so that we could get a conviction?" And I wouldn't go for that. I would throw them out of the office and no action.
In Miami?
In Miami, yes.
Were you in the
And then
city of
I
Miami
had,
or
I
where?
had a worse corruption situation as a prosecutor in trial. The cops disappeared with the bags of coke and didn't return it. And then you find out later on that there's contraband in the jail. That drugs sometimes are brought in by officers.
Well, yeah, who else is going to bring it in?
Yeah.
Right, right. I mean, it's usually corrections officers, I understand.
Yes.
Allegedly.
I've suspected that, I mean, I know, as far as I could confirm it, that officers have lied to me numerous times about very significant things. Pulling guns on people to order them to stop, and then they say they didn't. And that's important because if you pull a gun on someone, then you can argue that that person was in custody. So any statements that they made would have had to have been preceded by Miranda warnings being read.
Oh, the minute an officer pulls their gun out of their
If an
holster?
officer pulls a gun on you,
Yes.
then you don't feel free to leave. You don't feel free to leave. That is a circumstance to be considered when arguing that you were in custody.
Oh.
And so if they ask you questions while you're in custody, those are all suppressed unless they read Miranda first. So they just lie about pulling guns, and they do it all the time.
But which is
amazing.
If I may say, like, why don't you consider that corruption? The police lying to you
Because
you know, that affects somebody's life.
I guess because it is corruption. But the way I think about it, corruption, should be rare. And I don't think that's rare.
And maybe
So I think that's more common practice
and maybe
than
corruption is more like along the lines of a conspiracy
I have
concept
a
where there's
client-
more than one actor
But is
involved.
that
I think what we're talking
injustice?
about,
Yeah.
tell
Would
me
that-
what to say.
I have
is
a
pretty bad.
client that right now is going to have permanent injury on his arm. The police dog stayed on him for like over 10 minutes, and he's not going to be able to use his arm. And because he apparently had incidents from his past, I've been trying to get civil lawyers to take his suit, to take a civil suit for him on his behalf. And a lot of people don't want to touch it because, if people are not born into wealthy areas or they're from quote unquote a ghetto, their life, they've already had issues with law enforcement sometimes since they're kids, and that harms them later on, and it's very hard to get them justice. If it was, the police sometimes, there was no reason for the police. He was already stopped. There was no reason to stick a dog on him for over 10 minutes, and the pictures are just gruesome.
I'm sure they
Has your opinion of prosecution changed since
Yes.
your time as a 23-year-old? Do you think
Yes.
it's unfair that the way that they do people?
Yes. And I mean, I think that some cases do need to be prosecuted
Of course.
strictly, and that prosecutors do a great work to protect society, but you have to be fair and you have to be ethical
Right.
and,
Now,
and go for the truth.
but
Yeah.
so,
Not
so,
for a conviction.
so here's my main question of the day. And one of the big reasons that I wanted to have two experts like you guys on this program. This whole concept of the plea bargain, it's a way to make a deal to free up the court systems from having to try or hear too many cases from all these different arrests. And so there's, there's the arrest, and there's the arraignment, and there's the bond hearing, and then there's then comes this plea bargain. And
Plea bargain.
Flea bargain.
What? Plea bargain.
How do you, as the public defender and as a prosecutor, how does that even commence? What are the parameters of it, and how do you arrive at how do you arrive at what you're going to offer? Is there a chart? Is there a system? You pull it out of your hat? How does it work?
If the person has no criminal history, it affects if there's a criminal history or not.
Right. If they're a habitual offender, I understand all that, but how do
Who's
you?
doing the pleading and who's doing the
And
bargaining?
a lot of times, the government makes a lot of money because the advocate
Money?
program and probation, it costs money, and to be supervised costs money, and there's fines and court costs. So if someone doesn't have money, it's very difficult.
Have they ever given you the imperative to make decisions or choices that end up generating more revenue for the system? Is anybody saying like, whoa, you need to hit your quota this month, let's get some more
No.
convictions and get this
but
money rolling
a lot
in?
of people that are accused are so scared, and they're terrified because it's held over them, the concept of you're facing 5, 15, 25, 30
Right.
years of jail. So they'll sign their soul away to be on probation.
Probation's a horrible
it's a
decision.
trap.
And I spent my life as a public defender trying to convince young people, young minorities, mostly men, not to take probation, to take a jail term now so that you're not taking prison on layaway, which is what probation is.
Prison on layaway.
100%. Now, to talk about your question, because there are a lot of things to talk about.
A lot of parts there, right?
The biggest thing to consider as a public defender or a private attorney, if you've got a client who's in the box who can't bond out, or the bond is too high, or the bond is revoked, and he gets a plea agreement offered even on the first day on the arraignment, that gets him out that day, good luck telling him not to take it.
Oh, yeah, for
And the
sure.
worst case scenario, which happens all the time, and I'm sure the prosecutors are cognizant of these offers, CTS followed by probation for your client who's in custody.
What's CTS?
Credit for time served, meaning you
Credit
get out
for time
today,
served,
but you start
yeah.
your probation, and you will come back in a few months and serve your prison sentence because you'll violate probation by not calling your probation officer. You'll violate by driving without a license, by pissing dirty.
Right.
Pardon my French.
That means
There-
having drugs.
No,
in
we
your
got free
system,
speech here.
Yeah,
Say whatever
right,
you
right.
want.
You can violate in a number of ways. And so the first thing to consider when you're discussing them is what the client wants is the most important thing. But we are counselors. We are called counselors. We can't tell them what to do. We can't tell them not to plead. We can only advise them. And so one of the toughest things that I had to do was dealing with 18, 19, 20-year-old boys who are in custody, who have an option to serve, 100 days or something, which is not insignificant in any way. But on a felony charge where they're facing up to 5 years, when there's probation attached, if they violate, a judge can just simply sentence them to the max, and it happens all the time. And the hardest thing we have to do is fail to convince a young man not to get out today.
Right.
Stay in for 100 days. Please, trust me. It very rarely happens.
And
Oh,
also
yeah,
there's
I've heard the stories
deportation
personally.
consequences these days, especially that if someone takes a plea, they could be deported right away.
Will
Will
be deported
be
and are
deported.
getting deported before trials.
Left and right.
Are
Before
you
trials.
seeing that happen?
Yes.
Yes, all the time.
Wow.
Yes. In Miami, a lot.
What's like a situation?
Situation is someone is charged with anything. Let's say strong arm robbery or robbery by sudden snatch. You pull someone's purse. You're not a United States citizen. You get a bond amount, and your family posts the bond amount, and you have an immigration hold. You're gone. Once the bond is posted, ICE has 48 hours to come get you. And if they get you, you're going to Chrome and you're getting out of here. And they are deporting everybody, and they are deporting people before trial now. So,
Yeah.
I actually am in a situation where I have to advise some clients, like maybe you want to try to post the bond and get out and be deported because otherwise you'll stay here. If you're convicted, you'll
Chrome.
serve 15 years and then be deported.
And I've had
man.
situations with clients from very poor countries, and they told me that they risked their life to come here, and they told me they'd rather be in jail in America, Chrome or TGK, than to be back in their poor countries. And that says so much. Like, we're blessed to be in America, and of all the legal systems, America is probably the fairest.
It is 100%
Yes,
the
the
fairest.
fairest, yes.
Is
There
it the fairest?
Yes.
There is
Yes.
no better system in the world
That's correct.
than the United States system of criminal justice.
But if
now,
you don't
it is
have
corrupt,
money- but if you don't-
we have jury trials.
Yes.
The standard of proof beyond a reasonable doubt.
It's a high burden.
There's nothing like it elsewhere in the world.
Well, how many cops? You say cops lied to you all the time. How often?
I mean, hundreds.
Hundreds of police lied to you
Hundreds.
over the 6-year period. Hundreds
Yes.
a year or
On
hundreds?
thousands of
exaggerate.
cases.
Thousands of cases.
On thousands of cases.
Yeah.
I represented thousands of
City of
defendants.
Miami Police, Metro-Dade Police,
Pinecrest, Miami Gardens.
What's the number one
Hialeah.
type of lie that you hear from a cop?
I mean,
And not that they're
the
all
number
bad.
one lie is
Yes.
whether or not the encounter was consensual.
Yes.
Meaning what does that
Meaning,
mean?
I just walked up and asked him questions, asked him what he had in his pockets, and he told me.
Yeah, they say
That is BS. That is
course.
BS.
Right.
Yeah, they say that the defendant spontaneously stated
Mm-hmm.
in the police report.
The drugs were in plain
Yes,
view.
exactly.
Oh, I could just see them.
Yes, because otherwise they,
Nobody
it
leaves
would have
their
to be
drugs in plain
Mirandized
view.
and have a warrant.
Well, that's the thing, right? And so
course.
jurors,
Yeah.
a lot of the time, will not buy that argument.
Right.
But to put a defendant in trial before a jury is a huge
So
risk.
stressful.
I always tell them it's last resort. Unless you're hell bent on going to trial, let me do everything I can before we get to trial to get rid of your case and get you the fairest possible
Yes.
resolution. So you have all the options on the table before you make this decision. That's your decision alone to put your life before a jury and let the community decide. But
Yeah, and it's a scary proposition because you hear all these stories, and then you hear this trial tax, being
real.
laid on top of
tax.
that. So where you're going to basically maybe be punished for using your rights as a citizen in this country to have a fair and speedy trial. Now that is the other thing, speedy.
Speedy isn't always in the best interest of a defendant. In federal court, there's like a high speed because a lot of times it benefits the state to have a speedy trial because evidence gets stale, witnesses relocate, their memory's not so strong. But if someone's in custody, they do want a speedy trial.
Of course, the old expression, a minute depends on which side of the bathroom door you're standing on.
And people that don't have money sometimes, people that don't have money can't afford bonds, and they're literally.
Yeah, and now the whole bond system, we've had a show about bonds. United States and the Philippines are the only two countries that do money bond. And
I didn't know that. That's
yeah.
I didn't know that either.
unbelievable.
Yeah, we're the only two. And Washington, D.C. has done away with it, and they get an 88% return for people coming back to trial, which is the highest in the nation.
Bond,
No
is
money
not
bond.
to punish the defendant, it's to ensure that they're not a flight risk, but the system also has issues, the bond system.
Yeah,
has
because there's a
issues.
lot of people that can't afford even the $50.
Or they don't have collateral.
Right.
Well, that's the thing. When you're poor and you have prior criminal history, you're not going to qualify for a non-monetary release, so you're going to be in.
Yeah.
And the trial taxes, these are sometimes, you can't believe how significant they are.
Yeah.
The offer could be, so you have a
Give us an example.
example is you have a 10-year offer on, let's say, an armed robbery. A very difficult case, very serious case. You're facing life in prison with a firearm. 10-year offer, a lot of the times, are these things that people have to consider.
Yeah.
Because you roll the dice, you can get life. But trial taxes really do happen at 40 and 50 years. So you have a 10-year offer, you go to trial and lose, they tax you by 40 years.
Yeah, and in
It's
federal
unbelievable.
court,
And
they
they're
do that all the
protected
time.
by simply saying, "Oh, I learned new information during the trial, and that's what I based the 40 years on." It's not about.
Just like a
And in
game.
and in federal court, they add.
Sounds
time.
sketchy.
Oh my God, it's the sketchiest thing in the world.
Yeah.
And speedy trial, just to quickly get this in, you have a 175-day right to have your case tried in felony court, speedy trial. 90 days, I believe, in county. So long as there's no delay attributable to the defense, meaning that you fail to appear to court or the defense attorney takes a defense continuance, the case has to be tried in that period. If it hits 175 on a felony or 90 in a
Has to be tried.
a jury panel has to be sworn. So what that means is, and this is gonna upset you guys, but all that has to happen is that a prosecutor has to bring in 40 people to try to pick a jury from. And that jury panel has to be sworn, meaning the jury doesn't have to be chosen. If that panel gets busted, and what I mean by busted is enough of the people get themselves off because they don't want to sit, enough of the people get caused because they believe police more or they don't believe police. If you don't get 6 or 7 from that 40, the panel is what's called busted, and the speedy trial right has been satisfied.
Speedy
What?
trial, right?
Yep.
It's
So
being
175 days, you've been
satisfied.
waiting for your trial. You're in jail. You go. You get those 40
no.
jurors.
Oh, no.
They get sworn in. It gets busted. Panels get busted all the time. By
All
the
the
way.
time, yeah.
It
It's
gets
very
busted,
hard to get
and
a
that's it.
panel in Miami. People don't speak English.
You're saying that some little thing like this little technicality could create a person not to be able to have their day in court.
Constitution.
Correct. Now, you can always reestablish the right to speedy trial by filing what's called a demand for speedy trial,
Right.
which is 50 days. But I believe that when the speedy trial right has been satisfied on what's called natural speedies, this 175 and 90,
Yeah.
when it's been satisfied by the jury panel being sworn in, there is, I think, a new automatic clock, if I'm not mistaken. I'm not sure what the time is on that.
Okay.
But there's a new automatic clock, for instance, after a mistrial, that when a case was tried while on speedies, for an appeal, when the appeal overturns a conviction, for instance. If that case went to trial while on speedies, there's a new speedy trial clock right afterwards. So it automatically kicks in again.
It's confusing.
It is.
It is.
I'm sure
That's
if you've
why-
been
that's
saying
why-
hey, I'm a bit let 'em- go
That's
ahead.
why you need a lawyer.
But yeah,
People
somebody
who
that
try
knows
to
the system.
go it
Yeah.
themselves, try to go pro se. There's an old saying, and I think it's been thrown
Pro
around,
se means to go do it yourself.
do it yourself.
Yeah.
What is it? The lawyer who represents himself as a
As a
fool
fool
for a
For
client.
a client, right?
Yeah.
That goes for
True.
pro
Yeah.
se defendants as well.
Yeah, it's a difficult thing to navigate. I mean, it's very complicated, and I guess it's that way for a reason.
It is, but that's why I became a public defender, because I was very successful in high school debate, and so I can speak, and I always wanted to do something with it. But after law school or after college, I started to think about it and look at people I knew who were public defenders, and I realized that this whole system requires 7 years of education to understand it. Yet any regular person can be charged with a serious crime. So it's so unfair for especially people who are poor, who have no access to this. For people like myself and people like the wonderful public defenders who came before me and the people at the office now are great lawyers from Yale, from Harvard. We get really great lawyers. They're all doing it for the same reason. They're not doing it for the money. A lot of these people aren't going to become private criminal defense attorneys. They're doing it because this is really civil rights law. I
Yeah.
considered myself a civil rights lawyer.
Yeah, no, it's a tremendous contribution to the community. I for sure. I see people that work in these public offices, and I absolutely take my hat off to you guys
It's
because
literally saving people's lives.
for sure,
And losing liberty.
and helping the community in the neighborhood because we all live here together. You know, it's
Well, but at the same time, because it's not an anti-police show, it's an anti-corruption show. So some of these people that you encounter, and some of them are probably actual real criminals. Do they lie to you as well, ever?
Well, here's the thing. I don't really ask them if they did it because
No?
it's not important to me. It's important to me whether or not the state can prove
The
it.
state can prove it.
Because
beyond
what we
reasonable.
do at the end of the day is the same thing as the state. We are trying to reach justice. And so the way I describe myself when I was a public defender, and I think still as a private attorney, is that I'm a hurdle. I erect a hurdle. That's what I do. And if the state cannot get over that hurdle, justice is done. And if the state gets over that hurdle, justice is done. But without the erection of a strong hurdle,
Right.
everyone's convicted. There are no plea agreements. There are no reduced charges. Everyone is run over by a steamroller.
Right. So yeah, because there's different approaches to criminal defense. Some defense attorneys don't want to know what happened and they just want to see can the state reach the burden. But I like to sometimes not know everything, but to know as much as possible because I don't like surprises in court. But even if you know that your client did something, you just can't put them on the stand to commit perjury. But you still have to force the government to prove each and every element beyond a reasonable doubt, which is a very high burden. It should be a high burden.
it's interesting this whole concept of the burden and the proof, and because if anybody out there has never served on a jury, I highly recommend it. It is an amazing process. I was fortunate enough to do it a couple years ago on a federal
It's
case.
the highest civic duty.
wow.
It is. It's honestly, it's a tremendous honor, and I felt that. A very deep sense of connection to my community, to patriotism, to being a part of the process that is our legal system, and it was an honor for me, and it was very interesting, and it was very eye-opening. And it's true, the burden is on the prosecution to make the jury believe, you know what? Yeah, these people, they did it. Now, the case I was on, there was 3 defendants. They were trying them all at the same time. It was a federal case. You know what? The prosecutor, he laid it out, and we all looked at it, and we reviewed it, and these people were guilty. It was like, damn, there's all the proof. These people definitely, they did that.
That happens a lot of the time, and I imagine why it happened in that case.
Yeah.
Because
There was
they
one of the counts that one of the people, we said they were innocent because it seemed kind of sketchy. It was like, I don't know. It seems like they didn't have a lot of proof. It was more like just he said, she said. But the process of being on a show, when you were just saying a little bit ago about people wanting to bail out, or
Right.
what was the expression you used?
Cause. So they
Cause.
Yeah, cause means that. So when you're selecting a jury, each
Yeah.
side has a certain number of peremptory challenges, meaning I can get rid of that person
Right.
for whatever reason I want, so long as it's not it's a race, gender, neutral reason. Cause is different. Cause is I say I trust cops and I won't trust a civilian more than a cop, then you cannot be on the jury and you are stricken for cause. That doesn't cost either side one of their peremptory challenges.
Right, but it seems to me that also there's this thing out there in the world. Oh, I got called for jury trial. I'm trying to get out of it. I got to get out of it.
I get
The
so
wrong-
many phone
I
calls
think
like
it's
that
a-
from friends.
Yeah, I think it's such a bad idea because and I'm telling this to our audience, participate. It's an amazing adventure.
but then meanwhile you find out these 40 people are getting, cattle called into the thing, and it's used to violate people's constitutional rights to a speedy trial.
Well, I don't think that's the rule. Maybe there's the exception.
Well, no.
He just said it happens every day practically.
No.
Oh, not-
So
Often.
what I will say is that a jury panel being impaneled on a case with a natural speedy clock ticking
Yeah.
is rare. It's
Okay,
rare
it's
because
rare.
most of the time defense attorneys will immediately take a defense continuance for a
Right.
number of reasons, but the main reason being, like for instance, public defender, 60 clients if I have the C level. So there's CBA. C is third degree felonies. B is essentially second degree felonies. The A attorney handles all of the first degree felonies, armed robberies of firearms, the sexual battery cases, the murder cases.
The heavy stuff, yeah.
That takes a while to prepare these cases.
Yeah.
And so you don't want,
So you're filing to get more time.
Yeah, so you take a defense continuance. It's a delay attributable to the defendant, and so it busts the speedy clock. But you can always file a demand for speedy trial,
Okay.
which guarantees you get the trial in 50 days, or it gets dismissed after 65 days. So when 50 days hits, you can notify the court, and they have another 2 weeks. If it's not tried within that time, it gets dismissed.
I got a question. Have you ever seen a public defender lie, or have you ever seen a prosecutor lie in
Both.
court?
Sure.
Yeah, it happens.
Yeah, both.
Is lying
Sometimes-
considered ethical, or is that just
It
like
is
a regular?
considered it's unethical.
Yeah, it's unethical.
Lying is unethical.
not.
It is
Yeah.
news.
Yeah, you cannot lie in court.
Yeah, but people do it all the time. You're saying?
Not all the time.
But
I've seen people do it, and I've seen
Yeah.
both sides do it. There
Yeah,
are
but in Miami,
sketchy
we're
prosecutors,
very
there are sketchy public
lucky.
defenders.
Most of the colleagues we all get, they say like civil court has more, because when I do civil cases, those are even worse. When people are fighting about money, they
Oh.
become more vicious, more nasty. In general, with criminal court, the opposing counsels, we're more civil in general.
Very
Is that your
civil, yeah.
experience?
I haven't had.
So when money gets in the game, it makes people less civil. What is the least
It's sad
civil
because it
court
shows that our
interactions?
society values money more than liberty, when liberty is so valuable.
Well, it's also that's very sensitive when
Yeah.
you have someone's life on the line.
Yeah.
So
Sure.
I think that it kind of it's not lost on the prosecutors or the public defenders that you're dealing with someone's life. You know, the prosecutors don't take this job because they want to put minorities in prison for life. They take this job because they want to protect the community.
And people see it as the right side. Unfortunately, when I switch sides, I've been asked by so many people, oh, you went to the wrong side. Like, people assume that the prosecutors are on the right side and defense attorneys are on the wrong side. And it's not like that.
Listen,
there has to be good people on both sides.
They're both the right side. Nobody can do more good
Right.
than a prosecutor
Yes.
because a prosecutor can decide if a case should not be prosecuted and get rid of it.
Correct.
Problem is, a lot of prosecutors are afraid of their bosses. They are afraid of the rat race and the competitive nature of
They're
the
trying to
office,
advance their career,
and they
some
don't
of
want to
them.
look weak. And this is very big for purposes of plea agreements because they're not going to give you good deals because they don't want to look weak compared to their colleagues
but
who
a
are going to
process-
move up higher.
So
and
there's a
faster
little
than
bit
them.
of an ego thing going on there, huh?
A big bit of an ego thing.
Big bit of
The
an ego thing.
promotions are based
So
on-
how could that be changed? How could that be
Good question.
leveled out?
Make the prosecutors autonomous. Take away the career
I
criminal
agree.
division. Take away people who sit in a beacon on the hill, don't try cases, never talk to victims, but don't approve pleas. That's a problem with that office, in my perspective.
Okay, I want you to break that down for me one more time.
I will. So there's something called career criminal, meaning that if you have a number of convictions or a criminal history, you're going to fall under the purview of career criminal, meaning that no prosecutor has the authority to close that case to whatever they think is reasonable without approval from someone in the career criminal office.
Okay.
Career criminal tends to be people who have been in the prosecutor's office, state attorney's office, for a very long time, have long been finished with trying cases, have long been finished with interviewing witnesses, have long been finished with going into court, and they're the people who say yes or no to the plea offers.
And are
they
these people a
routinely
bit
say
hardened?
no.
And I
Are
had
they a
to
bit
meet
hardened
with-
by the
I
whole
think-
process?
I can't help but imagine that they are put in those positions because they are the hardest,
Yes,
least
correct.
reasonable.
I remember
That's what
we
it
had
feels
to,
like
we
to
didn't
me.
have
Right.
discretion on
Yeah.
career criminal cases; those were called red files.
Yeah.
And we had to meet with, with the division chiefs, and it was very. And as a defense attorney, I've had to try cases that were so dumb and ended up wasting time because it was an acquittal, or it ended up being a lesser included that I was begging for a deal for. So. Just because someone's a career criminal, they're going to ask for 30 years for
Let me-
someone that,
Let me give you an
Okay,
example.
so I want you to finish breaking down. So get rid of the career criminal department.
Well, I don't think you can get rid of career criminal because if you have somebody who is a career criminal and has
Okay.
committed a murder, for instance,
Well,
or
couldn't there
something,
just be a chart for that? Look, okay, this guy's got 5 things. He's, he goes
the
into
chart?
I think career criminal
We'll
should
make the
handle.
chart, the people.
I think career criminal should actually have their own cases.
Okay.
When they're the highest and most severe, and they qualify for that,
Right.
they should actually have them. I don't think career criminal should be removed from the process.
Correct.
They should know that if this doesn't work out, they're trying the case. Because it's very easy to sit in a room and say no to a plea offer if you don't then have to go try the case against the defense attorney.
Right.
and
you know?
waste a week or two and taxpayers' money.
Yeah. And so the second part of this.
Well, the second part, I want to point out a case that I tried a few
Yes.
years ago that I
Okay.
had to try.
Okay.
Because the gentleman's offer was 30 years. Now, this gentleman had a bad criminal background. He had committed robberies, he had committed numerous burglaries, numerous drug possession cases, but he had not been in trouble for about 15 years.
Okay.
But he picked up a burglary because he's a homeless man, and he stole copper piping from an air conditioning unit outside of an abandoned house. within what's called curtilage, which is a fenced-in area.
Okay.
That's technically a burglary. But it was an abandoned house that everybody knew wasn't being used. It was going to be demolished or who knows. But he was charged with that. His offer was 30 years in prison.
Yeah, I had a similar case, also a homeless man, also,
Yeah.
similar situation. Yeah.
His offer was 30 years in prison. He was facing mandatory life in prison if he lost the jury trial.
999 years.
Oh, mandatory life. And the reason mandatory life is he was called a gort. Gort is a violent career criminal because burglaries are considered violent career crimes.
Even if there was
Gloria
no
Taylor,
violence.
Even
Free
if
glow.
all you do is take apple from a fruit tree in a fenced-in area,
Yeah.
that's a burglary.
That's
Yeah.
a burglary.
You do that, and you're considered a violent offender.
Yeah.
Right.
Now,
Yeah.
now, at one point in this program, we had one of our guests explain the concept of the whole legal system, how these laws are often written for kind of the middle, the general. They don't really look at the far fringes of these activities. They're just kind of so. But it occurs to me that that we're all relatively understanding people, and that we should know the difference between somebody stealing an apple from a fenced-in area and somebody walking in and smacking you with a gun across your head.
Yeah.
There is a difference there.
Oh yeah. Well, look
Yeah.
at the Berg bat statute. So burglary with a battery, which carries life in prison. That is designed for someone who runs into your house, breaks into your house, and beats you up in your home.
Right.
That person's going to face life in prison. But if you get in a fight with somebody at a high school party, for instance, and that person goes to their car and you continue to follow them and they continue to
I've
fight, you
so
hit
many
him
cases
through
like
the
that.
window on his shoulder, and you're facing life in prison for
Life
committing a
in
burglary
prison?
with a battery.
Because you
Because entered his car with the intention to commit a crime. The crime is a battery, and you're facing life in prison. You're being denied bond, and that's the problem. Is that this one statute covers hitting someone in a car with a normal fight that he may have started,
right.
or invading a home.
Yeah. So how do we get these ridiculous?
Prosecutors need to be more reasonable.
Prosecutors are supposed to be
Prosecutors need
gatekeepers.
to be more reasonable.
They have to be the gatekeepers.
They're the ones.
And since this was the main question that we just started this part of the conversation is, how do we make that change? How do we make the whole prosecutor's office become more reasonable and have a change?
I can't think of any reason other than a new state attorney.
New state
But
attorney.
I'm
a this guy.
I worked at that
New
state,
state
at the state
attorney.
attorney's
You're
office.
fired.
I really look up to Catherine Fernandez Rundle. She taught us to be fair, and I think it's the best because having practiced in other areas in Florida, and I have an office in New York with a law partner, that in other state attorney's office, like even Broward County, is a lot stricter and less discretion.
I've heard that as well.
Yes, and I do a lot of cases in Broward, in Lee County. I have a case there in the news right now. It's much harder, and Miami is much more fair.
Is it that Miami's more fair, or is it that Miami is just more populated?
I think it's more populated. I think that, look, realistically, this demand for speedy trial thing that we spoke about, what if the public defender's office chose to file a demand for speedy trial on every single case and no longer was open to plea agreements? Enough is enough. Now, we can't do that because you can't use human beings' lives as pawns.
Right.
But if we did do that, it would break the system. You cannot try all those
Right.
cases.
It's
We're going to
impossible.
see offers come down all the way.
When I was,
Right.
but they don't
there
want
are
to
ways,
hold
but you
everyone in.
can't.
Because when I was a prosecutor, we had weekend bond hearings, and I was 23 years old and excited. I'm like, giving everyone, asking for high elevated bonds and asking people be held. And I thought that the office would be happy. They're like, the jails were so full like never before, and the
You sing
system's
it.
going to explode. You have to let people out, and drug cases, credit time served. Yeah.
It's another problem. Overzealous
Yeah.
23-year-olds handling
Yeah.
people's
Right.
lives.
Yeah.
How much effect can one
you know what?
prosecutor create?
The thing is, I think that prosecutors need to see the jails. I never saw a jail till I became a defense attorney.
Yeah.
The prosecutors, you throw out numbers, 5 years, 364. You don't know what it means to be in a jail, how horrific it
You're
is,
right.
the conditions.
Maybe
Put 'em out in jail.
Maybe
Weekend
prosecutors
in
should
jail.
spend. Yeah, maybe they
Weekend
should
in
spend
jail.
a week in jail.
I think that it's
Week in jail.
important. No, but
2
at least,
weeks.
at least to visit and see
Month in jail.
how horrible jail
I
is.
think they should spend time with inmates to see that they're human beings.
Exactly.
Because I don't
True.
think they grew up with that type of person.
Right.
Right.
A lot of the time, the people who work for the state attorney's office come from a typical background where they're not exposed much
I was
to
very
Privileged.
sheltered,
Yes.
very
Privileged,
sheltered
yeah.
from an Orthodox Jewish background.
Yeah.
And to me, if someone was arrested, they're a bad person. Now,
Right.
people are starting to become more open-minded, but I think like 15, 20 years ago was assumed that if you were arrested, if you had handcuffs on you, you were automatically guilty. And that's stuff that we go over with the jury also to see if they understand that.
Listen,
Presumption of innocence.
I've been arrested a couple of times, and when I was on that jury, the judge, he asked when they got to me, "Ever been arrested?" And I was like, "Uh huh," and he was like, "I'm sorry, but I have to ask."
Right.
It was for disorderly conduct in college,
Yeah, of course.
and that happens, I'm sure, to a lot of people. It has nothing to do with my character or how I behave. I'm, not a violent guy. I didn't, but yeah, I got arrested,
Right.
and then I got arrested here in Coconut Grove. They were doing like a little roundup with a big paddy wagon, and it was for public drinking. I had a beer. Me and my buddies all grabbed a beer. We were all of age,
Quotas.
and they rounded us up, and they ended up dropping the cases on both of those things.
But those officers got a quota.
Right.
They met their quota for arresting you.
Right. So I have a
that's something that
question.
could change.
I have a question that I'd love to see you two show us how a plea bargain goes down.
Yeah.
Okay.
Okay. So you're the prosecutor.
Yes.
Okay. You're the public defender, and Jay Cattell over here is
I
the
didn't
criminal.
do it. Innocent, I'm free.
Is the criminal.
Oh.
Okay. So
Don't talk.
and hold on.
That's the first thing I'll tell you.
Action.
Okay. Don't say anything. That's the first thing I'll tell my client because you're gonna. This case should be dismissed.
Why should it be dismissed? We have witnesses, we have probable cause affidavit, he has a large criminal history. Why should it be dismissed?
Because very clearly the judge made a mistake on the probable cause finding and shouldn't have.
You're saying that Judge Stone made a mistake?
Yes.
Judge
How?
Stone, don't make me-
Either made a mistake or made a bad decision in finding probable cause. That said, I do believe that once the depositions are all finished, we'll have a very valid motion to dismiss.
Well, then take your depositions and we'll see after that.
Okay, the problem is the gentleman's in custody. And what
I
I'm asking
understand,
you,
but he does have some bond. He has bond.
he can't afford a bond. He's a public defender client. And so the issue is, this case will be dismissed. I'm very confident that it will be. The problem is that he's going to sit in custody for maybe 200 days until I'm able to get all these officers in for depositions, file the motion to dismiss, give you time to file your written response.
Well, then file a motion for a bond reduction and for a house arrest.
I've done it.
I don't see it here in the file.
I'm not lying to you.
Okay, so assuming that, you should set it on calendar, and then we'll
Would you
litigate it.
will you agree to house arrest?
Let me see. So what were his, can you tell me what his prior, I see here
Yeah,
that he
he
had a
had-
few priors.
He has a number of priors, but none of them are violent. They're all drug possession cases, cocaine and
But
marijuana.
how do we know that he's safe for society? And I see that he has two small kids.
Mm-hmm.
How can you ensure their protection?
How can I ensure their protection? There's no
Yes.
allegation that there was anything done wrong to the children. If you want to speak to them or his mother, his wife, I'd be happy to make them available at a bond hearing. If you would agree to release to house arrest to give us time.
What
to-
about a release to a rehabilitation, to rehab?
Again, this case should be dismissed, and so he certainly shouldn't be required to do anything prior to the resolution of this case for him getting any kind of
Your
assessment.
client
of
has a
culpability.
strong drug addiction. It's obvious here from the allegations in the A form and from his history of arrests. So I think it's in his best interest to have a court-ordered rehabilitation,
What kind of offer do you have then?
6-month inpatient,
Mm-hmm.
and followed by 3 years probation.
Okay, so would you make all the witnesses available as soon as possible so that we could have them deposed so that I could
Oh,
expedite the
absolutely,
process of
absolutely.
filing the motion to dismiss because I cannot agree to plea him out to something that is 6 months inpatient
Yes,
treatment.
however, the longer you wait, it's going to be a jail offer.
What I'm telling you is
Don't do me
that I know
anything.
the case will be dismissed. I'm telling you that not because I'm trying to posture and
my
get you to
life.
believe
You
that
know
it will.
how many times I hear this case will be dismissed? The last case I tried, they said it was going to be dismissed, and I got a 15-year conviction.
Okay. So you're not going to dismiss the case.
Not at this point.
your
I don't have,
offer-
my office won't allow me to do it. My hands are
That's a
tied.
problem. You should stand up to your office.
Are you going to employ me in your firm?
If you give me the dismissal, yeah, sure.
Corruption.
No, but so here's that's the big
Allegedly.
issue, right? And
Yeah.
that's just one
Yes, so
example
that's-
of the kinds of
Yeah.
things we're dealing with.
It's fascinating.
Practically,
Right.
this guy can wait until his case gets dismissed, but he has to do so in custody. And so if a reasonable, she's not even offering jail, she's offering 6 months inpatient treatment, which is a setup for failure because he's going to find drugs in that inpatient treatment facility and violate probation and do prison.
Deerfield Beach or Delray.
Yeah. But that's what's going to happen. I mean, I had a client who his offer was 18 years. He was in what's called rock court, repeat offender court. His offer was 18 years because he had violated probation so many times on an armed home invasion robbery case, which is carries life in prison, very significant. His offer is 18 years, and after a lot of begging, I was able to get him an offer of an inpatient treatment facility for, I think, 3 months. Within a week, he had to be hospitalized showing symptoms of methamphetamine use.
Oh, man.
Within a week, an inpatient treatment facility where you're locked in. It's like jail.
Yeah.
Right, but sometimes, like certain defendants, certain times when people are arrested, sometimes it helps that they should, because otherwise I had a client that his mother begged for me to get him out, and it was the saddest thing. I got a phone call and I got him out, and he died of a drug overdose. He was found dead in his apartment. And, also we do need to help people. So it's a balance.
Listen, the whole drug addiction problem is 3 shows all on their own because it's a very complicated. Yeah, it's complicated, and there's conflicting opinions, but the evidence is very clear that the treatment concept works better than all the other ideas. But on going back to these sentences, what's amazing to me is during this entire conversation, Brad, I've heard you say this carries a life sentence on so many things.
So many.
Yes.
You wouldn't believe it.
Yeah.
It's astounding to me that so many little things carry a life sentence.
The average people
Let me
think
give you
that
some
murder
examples.
is the only thing that has a life sentence, but there's so many.
I mean, I'm hearing like a guy punches you through the window. That's life. I'm
Punch
hearing
through
if
the
you do
window,
this,
life.
it's life.
Do this.
How about
It's
this?
insanity. How did this happen?
What about this? Okay, I break into your house. There's nobody there. I shouldn't be doing it. But I break into your house, and I'm stealing your watches, and I'm taking your TV. These are all bad things. You should be punished for that.
No doubt.
But you shouldn't spend life in prison.
Correct.
But I see a firearm, and I take that too. And suddenly I've committed this burglary while armed with a firearm, and I'm facing life in prison. By virtue simply of stealing it. Here's another example. I have taken copper piping from an air conditioning unit on a house multiple times in my life. I've gotten breaks on it, but I've done it multiple times. These are violent felony offenses. I do it enough, I pick up another one of those where I have taken the copper piping from the air conditioning. The prosecutor, the state attorney's office, determines I've caused $1,000 in damage. So I have that background where I qualify for what's called a violent career criminal.
That's the one.
And I have a second-degree felony, the burglary, very simple case. I'm facing 30 years minimum.
It's true.
And because of that 30-year minimum that I'm facing, which is ridiculous,
Crazy.
I'm facing mandatory life in prison because the $1,000 in damage to a house when you burgle it carries life in prison.
Yeah, if a homeless person, when I was a state attorney, there was a case where a homeless person he went to steal, there was laundry hanging in the house, and he needed a blanket outside of the house, and the office, wanted 30 years.
I kick a $1,000 door down, and I go in your house and I steal a roll of toilet paper. I'm facing life in prison.
because
Life.
of the $1,000.
$1,000 in damage.
If someone's a
Burglary with
criminal.
Really?
$1,000
So-
in damage. That happens
Life.
all the time. But
All
who's
the time.
999 years?
Now, they
But
don't
whose
charge it.
discretion is it
The
at?
state
Once-
attorney's office, they don't really charge it that way.
But is it the judge or the state who
State
decides
attorney.
It's
that's
the
the
state
person?
attorney.
The
and
state
that-
attorney can either file it as a
Yeah.
burglary
Yeah.
or a burglary with $1,000
Being a
in
state
damage.
attorney sometimes is more powerful than a judge because the state
always.
attorney could
You can just
dismiss
dismiss it.
cases.
Right.
And I was like a 23-year-old, 24-year-old with that type of power. That's
Right.
really.
You had that? Or
Yeah.
your boss? You
Every-
yourself
She
as a
had that.
23?
If I said no action to a case, whatever I announced on the record, it was.
Wow.
Look, picture a rogue prosecutor who really wants to do good, okay? You got a case where a guy's facing life in prison for that. It's up against the speedy trial period. If you dismiss a case during speedy trial and you don't refile it within that small period of time, 15 days you have to refile it, it can never be refiled.
Yeah.
So you may get fired for dismissing it on your own without approval, but you will have saved somebody's life if you don't agree with what's happening because the judge won't approve anything less than 30.
We need
and your
more
boss won't
rogue
approve anything
prosecutors.
less. No, you don't need rogue
No, but-
prosecutors. You need the hiring
Yeah.
practices to change. You need the bosses to make sure that that the younger attorneys understand that they have autonomy on the vast majority of their cases. If you feel that it's right to dismiss a case, don't be afraid to do it. The problem is in your office, I understand. You have to write a
Right,
dismissal
closeout
memo,
memo,
right? You have to
closeout memo.
you have to justify what you're doing to a boss in writing.
Right.
So that right off the bat, it's more work for a 23-year-old girl who has to suddenly start writing and explning. I'm not going to do that. I'd rather
But
just
I ended
no,
up
6 months
switching
inpatient
sides.
treatment.
I ended
Right.
up switching sides after 3 years. I became a public defender. I had a lot of good experience at that office and everything. And, there does need to be people protecting victims and
100%.
protecting society. And it's a balance that there has to be good people on both sides to protect the Constitution.
Yeah, we
Yeah.
never, Felony Miami never says that there's not criminals and that there's not a need for a criminal justice system. It's just how it doesn't seem to be functioning properly. And when you sit
Corruption.
here, it's not even corruption.
Injustice.
It is injustice.
Injustice for all.
That's
Where
correct.
there's injustice for one, there's injustice for all.
There's a lot of
Always.
injustice.
Yeah, and
It's very sad. The work we do,
It's
we
the
see a lot of
saddest thing.
depressing things. Very sad.
And we're focusing on the outliers. We're focusing on these cases that you just cannot rationalize how they fit in with the opposite end of the spectrum carrying the same sentence. There are a lot of people. I mean, there are a lot of people who are charged with crimes who need to do who need to accept responsibility. I
Right.
mean, that's the vast majority of plea agreements are because you're going to lose your trial, sir. And that's the toughest conversation that I have to have with my clients. Like,
Right.
if I can get you 20 years,
right. And how
You
do
have
you
to take it.
And how do you have that conversation? Like, here's your client, Jake. Here's your client, Jake Cattell.
I didn't do it.
He's facing it down.
I didn't do it.
How do you come to him with what the prosecutor just handed you as a deal?
it's over the 6 months inpatient treatment.
Yeah, or whatever it is, even if it's
Well,
10,
even if they're
15 years.
innocent.
Well,
What
I'll
if-
explain.
all right.
So I'm never going to tell you I know you did this, okay? But what I'm going to say to you is that this is what the government's evidence is going to be able to prove. And this is what your criminal history is. This is what the guideline score is. This is what your minimum mandatory is. And so your offer right now is 25 years. And it's a 25-year minimum mandatory sentence because you used a firearm, you discharged it, and you hit somebody. If you lose, this judge will give you life in prison. You have to know that. And I can't tell you what to do, but I'm telling you that I believe you will lose. I believe that there are too many independent witnesses who say they watched you shoot.
Oh yeah, they're
Who
gonna
say they
believe.
know
They're gonna
was-
believe. They're gonna line me up,
Okay,
and they're gonna
now,
believe. But
I
have you ever
can't-
advised a person that you believe to be innocent to take a plea accepting guilt?
I have advised a client that I was not certain was not innocent to take a plea to a much reduced sentence.
Right.
because
No,
at
it
that
makes
point-
sense,
because
logically.
At
And
that point,
that's
what
a
you're
plea
doing
of
is you're
convenience.
You're mitigating the
protecting
damage,
yourself.
Yeah. Sure.
But have you
You're-
see it happen? Because we've heard from like our street information that happens all the time.
Yeah, there are innocent people in jail.
Yeah.
So
And again,
Something
you had referred to your jury had found a gentleman innocent of a charge in your federal case.
Yeah.
That you found him not guilty. There's a difference between guilty and not guilty and innocent.
Correct.
We don't have to prove, first off, the defense doesn't have to prove anything.
right.
Right.
But you never want to get in the business
The
of trying
defense
to
has
prove
no
that somebody's
burden.
innocent because that's not the standard. The standard is guilty or
Correct.
not guilty.
Correct.
It's like guilty, not guilty, innocent. You
And
don't
it's-
have to prove that they're innocent.
Yeah,
Right.
in a trial, the defense has no burden. Like at the
Right.
public defender's office, we would tell the jury, we could be sitting here playing cards, playing chess, being on our phone, all the burden is on the state. But in reality, juries want to hear from the defendant, even though there's a right to remain silent. And it's very stressful to be a defendant because even though you really have no burden, essentially the odds are stacked against you in a
But
lot
because,
of
of
ways.
course, because the circumstances that you're facing are terrifying.
It's the biggest roll of the
Terrifying.
dice. And as I tell all my clients that I have to tell you this because at the end of the day, the jury comes back guilty, you get taken away. I don't. I go home and I go home with my wife.
Exactly.
So it's your decision. But I do want to give some hope. The vast majority of prosecutors are reasonable. The vast majority of plea agreements end
Yes.
reasonably.
Yes.
Okay.
They really do.
Yeah.
Yeah.
And I do think that this new wave of prosecutors are vastly more liberal than the people that I
Yes.
saw 6 years ago. And there's a lot of turnover. You know, that
Yes.
3 years and they're gone.
Is
There's a
that the
3-year
average?
commitment. Yeah.
3
so
years?
3
Do they
years.
burn out or what happens? Have you ever
No,
seen
there's a
people?
commitment. You have to sign up for 3 years.
have
Yeah,
to
you
stay
can't
in
get
the
out.
At the
uh,
state attorney's
Israeli
office.
army.
The
Okay.
attorney's office, there's no commitment, which I think results in them staying longer than 3 years.
Interesting.
But
Have you?
the system works. In Miami, it is vastly more reasonable
Yes,
than
it
it is
is.
in Fort Lauderdale.
Right.
Most of these cases get reduced to, if most of these good cases will not go to trial. That's what I always
Yes.
say. If for instance, if I have a young public defender telling me like I'm going to trial next week, this case is a guaranteed winner. I've been there a long time. Maybe I'm jaded, but there's no way that case is going to trial. It's getting dismissed, or you're going to get a great offer, and that's good. That's how it should work.
Yeah, that lets the system function. But here's one of the things that I think that I'm curious of your opinion on the importance of so many people are being put up for life in prison. And there's a lot of people going to prison for terms. So what happens? There doesn't seem to be any connection between the prosecution's office and the actual jail and the actual what happens to our citizens and our communities once you've made these pleas and you've said, okay, that guy's going away for 10 years. Now what? Like, what do we do? It seems like it's just a punishment system, but what about some education? What about some rehabilitation? What about some?
Do have, like, especially in the federal system, they have a RDAP program, which the sentence gets reduced for.
I see Brad shaking his head over here.
And they try to have
System of punishment.
Well, but they try to have also.
Deterrence.
They give people GEDs that didn't. They try to rehabilitate.
Yeah.
What is giving someone a GED after giving them a felony conviction and ruining their life?
Exactly.
It's worthless.
Yeah.
And a GED is worthless for somebody with a felony conviction. And if that felony conviction is burglary of copper piping, it's a violent felony conviction. This system is not rehabilitative. It is punishment
Yes.
to deter future crime.
But it
lot of
seems
people
that it
become-
doesn't. And there's empirical evidence that says that this doesn't. It's
A
just
lot
like
of people
capital
become
punishment
worse.
doesn't stop
The
people
young
from.
people committing these crimes have no idea what time they're facing. They have no
Right.
idea
Right.
how significant this stuff is. All they know is, look, a lot of the times their fathers are spending life in prison. They don't have a masculine figure in the community other than gangs or troubled groups.
Yeah.
And that's who they want to impress so that they feel masculine themselves because they don't have it at home.
They feel connected.
And we are taking their father figures away.
Yeah.
And
We're
sometimes
locking them up for
jails.
life, and we're removing them from the communities, and it's perpetuating.
And
Sometimes
what are the
jails
main
make people
reasons for
worse.
that?
They make
Racism.
No,
people-
of course,
Racism.
no. Criminal. Listen,
Racism.
jail
Racism.
makes criminals better criminals, and it
Yes.
makes people that weren't necessarily
Yes.
criminals.
Yeah.
It's not working.
I grew up in Palmetto Bay. Where I grew up, when cops are driving around, they're protecting me. In
Right.
an impoverished community, they're not protecting. They're driving around looking for who to arrest.
Persecuting.
And that's how racism happens.
Yeah, and if someone doesn't have money to defend themselves, it's very, very hard.
Unless you get a public defender. And then it's not.
But a lot of the public defenders are overburdened.
They are.
Yeah.
But they still, but the one, like I said, Miami is very lucky to have a great office.
Yeah,
the
they
people
do.
who do go there can handle more than they have.
The
that
hiring
said-
process at the public defender's office was extremely rigorous, even more rigorous than the state attorney's office.
Oh yeah, you have to be interviewed by a panel of like 8 people.
And
who
you're
ask
they
you lots of
fire at you
questions.
Why
questions.
wouldn't they be exactly the same hiring practices on the?
I think it's harder to be a public defender. You have to be creative. You don't just ask the officer to tell the jury the story and have them convict based on that. You have to think of a creative way to challenge the presentation of evidence. So it's a much harder
But it's a
job.
harder
Yeah.
job in a way to be a prosecutor because in reality you have to prove each and every element beyond a reasonable doubt, which is a high burden if juries and judges make the prosecution reach that burden.
And it's
A lot of times judges help the prosecutors along.
Oh, yeah, I
more
believe
often than
that.
not, they help the prosecutor along. In federal court, it's very difficult because you don't have cops telling the story.
Yes, it's
you have
federal
CIA
agents.
or
Right, or
FBI,
FBI
agents,
or Homeland
and they're
Security,
like,
yeah, exactly.
They do an
The
impeccable
Secret
job,
Service,
and
yeah.
the U.S. attorneys are impeccable. I mean,
Right.
it's
Those are
very
the top of
difficult.
the
I don't
job.
believe
No,
any
that's
of
a
them.
whole nother. Yeah, it's a whole nother.
a whole
level.
nother world.
It's true.
We
yeah.
want you on our jury.
Oh yeah, you're never getting on a jury.
Well, it's good
No
because
prosecutor is ever letting you
hey,
on
check
a
it out.
jury.
Every
Are
time
you
they
kidding?
send me a letter, it never gets to me anyway. So
Exactly.
I haven't been on a jury lately.
My
but-
biggest regret is never having sat on a jury because there's no way
Yeah.
we'll be able to get on
No,
a jury
no.
Why?
because they're going to strike the lawyer.
Yeah.
Oh,
I one
got
time
you.
had
Yeah,
jury
it
duty.
took me years to
Yeah.
get on one, and I used
love to get
to
on one.
talk to friends of mine that are in the system. I was like, "How come I never get called for jury duty?" And they're like, "Why? Do you want to be?" I'm like, "Well, yeah, I'd like to
They
see how
probably-
it works."
They probably think you're too liberal, but on the case where the prosecutors let you on, it was probably too strong a case for them to even care.
Honestly, it was the questions were like it was a bank fraud case, so it was questions about
ever
how do you
find
feel
out-
about banks.
You ever find out how much time the guy got?
I never found out the sentencing.
I bet you
No,
it'll blow your mind.
really.
I bet you it's in
Especially
the
in federal, they
years.
punish
I bet you
people
it's
for
in the
going to
hundreds
trial.
of months.
Really?
Yes.
Bank
In
fraud is
federal, they try.
punishment,
they,
deterrent.
Yeah.
Bank fraud, you get
Money.
When I was a paralegal for Roy Black, before I went to law school,
Uh-huh.
I worked on a case where a gentleman got 372 months for bank fraud.
And a lot of times the
30 years.
sentences are consecutive and not concurrent.
And those are federal cases always.
Federal,
yeah.
Bank fraud, any fraud against the government, wire fraud, that kind of
I
thing.
have a feeling because this particular case that I was on, it was 3 women, and
Wow.
yeah, but
rare.
I believe that they were I believe they were pawns
Okay.
because one of the witnesses they brought in had been one of the people that they tried who she agreed to
testify
cooperate and testify against them. She was title agent people and mortgage broker people. It was during the whole build up to the collapse, but in the whole process, they kept talking about these 3 other people that were like the orchestrators that they hadn't gotten to yet. So it occurs to me they were building a case to get a guilty plea, to then
Yeah.
turn around and tell these people,
100%.
you guys
Right. And
We
then
gave
you'll get a
you-
reduction.
We gave you
You'll
every
get a reduction.
opportunity to
Right.
cooperate. You
Right.
didn't. Now you've been convicted. Do
Right.
you want to cooperate now?
Right.
Good.
And I'm
Perfect.
sure.
And that's
yeah.
how the federal system works.
Right. Yeah.
But-
So I never even followed up to see what the sentencing was because they dismissed
Yeah,
the
you're right.
jury before. But I'm sure, based on the other people that I saw,
They got a reduction for sure, and they
sure.
definitely testified. And they didn't.
and
even
they
have to
definitely
they
testified
didn't-
against these other people. I'm sure of it.
They what's interesting is that they may have had in their agreement with the government that they have to testify to get the benefit. And if the jury
Right.
if the trial doesn't go to trial and they don't testify, they don't
Oh,
get the
really?
benefit. Oh yeah.
No benefit.
So
Hey, but-
yeah, because no, they may never actually even get to those people or find
Correct.
those
Right.
people. What if
Or
they-
those
Sometimes
people
they're
will
out of the
or those
country.
people will take a plea
Right.
and prevent
It's
you from
crazy.
getting the benefit.
There's a lot of crazy stuff happening, but what I want to know is how do they actually have a justification for giving people who are committing what are not actually these violent crimes classifications as career violent criminal offenders? What is that? Like, how do we destroy that?
I mean, I think burglary, I think burglaries across the board, no matter what, all being considered violent, is one of the great travesties of our legal system.
Travesty.
Because somebody, look, I can't tell you how many homeless cocaine and crack addicts I had who stole bicycles from backyards who became people facing decades in prison because of that. That is not how the system
That's
should work.
evil. That's evil.
It is just evil.
That's
I mean,
evil.
I don't
That's
want to
my
see someone in
opinion.
my backyard stealing my bike. I don't.
No, hell no. I need my
But I
bike,
don't
but
want
you're
that
not going
person facing
50
life in
years.
prison. I don't want that person facing decades in prison
crazy.
because they did it a bunch. Right.
Yeah,
yeah,
I had a
I agree.
client that someone stole his bike and the police didn't do anything, so they took him and his friends tried to take matters into their own hands, and then the prosecutor also wanted like a ridiculous, and it ended up, resolving well in the end, but I had to present mitigations and it was really, yeah.
Well, what was your greatest victory as a prosecutor, you think?
Oh, as a prosecutor?
Yeah.
I had a trial that I wanted to dismiss the case. It was a domestic violence injunction case, and in criminal court, a buffer violation. And I didn't want to try the case. I wanted to dismiss it because the woman, the alleged victim, she invited the defendant over to have sex with him, even though there was a restraining order. She said, "Baby, I love you, just come over." She wanted him out in the morning and called the police. So they charged him, and I felt that the case should be dismissed. I ended up getting a conviction, just trying it half-heartedly. And you're not supposed to give diversion after you try a jury case, and I gave diversion so he was able to keep his record clean.
Nice.
I've tried far too many cases that I'm happy to admit where clients were facing life in prison, and those cases should never have gone to trial. But my greatest victory, I think, was a gentleman named Gabriel Martinez, who was facing life in prison for armed burglary. And let me tell you what this young 5'4", 120-pound person who had both his hips replaced at the age of 11 did. This person has never taken a step without crutches in his life. But he was alleged to have grabbed the machete from the back of a pickup truck of maintenance workers and banged the side of it. No, not from the back. Picked it up from the next to the front driver's seat.
Okay.
By entering in and taking the weapon, he committed an armed burglary, facing life in prison. And,
Madness.
And we had to go to trial
Yeah.
because the offer was prison. And thank God the jury came back not guilty.
Thank God.
Thank
Yeah.
God
And as
we
a-
lifted his
yeah.
pant legs up and showed the
Wow.
jury that he had completely atrophied calves and that
Unbelievable.
the story was fake. I went to trial with a trial partner named Sasha Pernick, who's now does capital litigation for the public defender's office. She's a phenomenal lawyer. I've tried a number of cases with her. But that was my biggest. Gabe was kind of an asshole. He was an incredibly annoying guy. Incredibly annoying guy.
Yeah.
But this man didn't deserve to even have to go through the process when the jury came back not guilty, to see him break down, to see that he couldn't help but show us that he realized what was happening was the greatest moment of my life.
You're giving people their lives back.
Yeah.
I've had so many acquittals in Miami, Broward County, where people were facing a lot of times, and a lot of times the juries came back on serious felonies in 5-10 minutes with a not guilty with an acquittal. And my client in Broward County was so happy because he was facing 25 years. And he jumped up, and the judge said, "I'm going to hold you in contempt for 5 years," because he was expressing his joy. And it's just, so I had to have him, sit down and apologize to the judge. And, but yes.
There's a lot of egos in
Yes.
there, huh?
Oh my God! One of the worst things I ever saw was a guy was convicted of Medicare fraud in Savannah, Georgia, on a federal case before law school I was working on. And when he was convicted, the woman, the wife, she let out just this wail, this just gasp. Within 10 seconds, the judge ordered her removed physically by the marshal.
Wow.
Yeah.
Yeah.
Have you
There's
ever
a
met
lot
a
of ego
corrupt
going.
judge? Or did I already ask you that?
Listen, clearly there is work to be done. And I am grateful that you two are both part of the system, and that you've committed parts of your life to working to make it better. And I'm really grateful that you came in here today and shared your experience with us, and it's very enlightening. And I'm sure we could talk about this for another hour. Yeah. And honestly, I'd love to have both of you back on the show.
We would be honored.
Yeah. But for today, if you're looking for a bargain, don't take a plea bargain.
Don't take that plea
Or
bargain.
consult with
Yes.
an attorney.
Or plead the
Consult.
fifth.
Yeah.
Definitely don't rush to a plea bargain.
Right.
Let your
Right.
lawyer do all the work, because there may be another avenue to get rid of the case.
Yeah.
And don't let a prosecutor telling you that offer is going to be gone scare you.
Right.
Never.
Right.
Because you always have a jury.
Right.
Exactly. You always have an option until you're out of options. For the Felony Miami team, thank you for listening. I'm Joe Stone. We'll see you next time.
Salute. Hey, respect. Thanks for coming on the show. Yeah, it was an honor
Thank
to
you
be
for
here
having
too.
us.
Thank you so
For
much.
sure.
We're honored to have been here.
Check out felonymiami.com, and also check out the show on iTunes, Spotify, SoundCloud, YouTube. Check out the RSS feed. Check it out on every digital platform on earth.
Jay Cattell, blogger extraordinaire.
Writer, photographer, artist, filmmaker.
See you next time.
Well, it's early in the morning. Then when I ride, Lord and Mama. Well, it's early in the morning. Then when I ride, well, it's early in the morning.